So welcome everyone to the first event in what is shaping to be a fantastic Horizon project on the Faculty of Law, University of Belgrade. It has to do with philosophy of law. We even started with these events a bit earlier because scientific events in the project are not planned before the 6th month. But we were eager to do something that would introduce the students and that would introduce those who are going to participate in the project into the stuff that we are going to do in the next couple of years. So we had this idea of having jurisprudence jam sessions, informal meetings to introduce students to problems of logic, language, and practical rationality. It is our idea that the problems of language, logic, and practical rationality underline every legal problem. And if you're on your first year, you may not know that yet. If you're on the 4th year, you might be starting to notice this. But anyways, we'll be dealing with this both scientifically and by lecturing in the next 3 years. The sessions are divided by cities, and what fantastic cities they are. So we're doing the project with Genoa, with Surrey, and with Lisbon. And philosophers of law from Genoa, Surrey, and Lisbon are today with us, as well as members of the administration for Genoa, and I'm really glad to see them here. Our first day will be devoted to language and law, and our guests will be Julieta, Rabanos, and Andrej, Kristan. But before we start the scientific part, I would like, it is my honor to present to you, and I'm really glad could be one of his first appearances as the first appearance as Vice Dean for International Cooperation of the Faculty of Law, University of Belgrade, and I'm really glad to see him in this position. Marko Ivanović will address you shortly.
Thank you very much. What an introduction. I'm very happy to welcome you to the University of Belgrade Faculty of Law. I will give a few opening remarks on behalf of our Dean, Professor Zoran Mirković, who unfortunately couldn't join us today, but who nevertheless I hope that you can all hear me now. So, as you have heard from Professor Spaić, we are at the beginning of a very intense and eventful week, a week that will mark the kickoff of academic activities planned under the framework of the Horizon Twinning project entitled Advancing Cooperation of the Foundations of Law. This project gathers the universities of Genoa, Lisbon, Surrey, and Belgrade, and it has an invaluable importance for mutual exchange and enhancement of knowledge, but also for the promotion of scientific and administrative capacities of the participating universities. The University of Belgrade Faculty of Law is very proud to be a part of this project, and we are profoundly grateful to Professor Andrej Jovanović and to his team for all the efforts they invested into making their ideas a reality. I'm sure that all the activities planned under this project will help building some new bridges of cooperation between the participating institutions, while at the same time further solidifying the already existing ones. Belgrade Law School has a long tradition of studies in legal theory and philosophy. But for a tradition to continue, it is vitally important that it keeps up with the challenges of modern times. So precisely to that effect, the conference that is about to start takes a refreshing approach to organizing the scientific discussions. Just as the regular jam sessions, I hope that these jurisprudence jam sessions will help philosophical ideas resonate better and farther, and thus attract more attention. So we are very privileged to host this conference, and we are really looking forward to all the debates that will take place in the days ahead of us. And speaking of this rise of interest in legal theory and philosophy, I am very happy to see that it is no wonder that the end of the week will be dedicated to the ones whose time is yet to come. On Friday, the students, or should I better say the young researchers, will gather at the 9th Student Conference in Theory and Philosophy of Law, which will be dedicated to one of the most pressing issues of today, the future of international rule of law. That event will close this magnificent Belgrade Legal Philosophy Week. Seeing all these events and all these discussions that are ahead of us, I do not want to take any more of your time, since I'm sure that you're all anxious to get the debates going. So I would like to sum up this short address in two messages. The first one is enjoy Belgrade Legal Philosophy Week and all the activities that it has to offer. And second, speaking of the jam sessions, please don't stop the music. Thank you.
Thank you, Marco, for this wonderful and inspiring address. It is an eventful week, and Marco managed to mention almost everything, especially the important student conference that we've been holding for 9 years now. Is the 9th year of the student conference, so I expect you all to be there. It's an absolutely fantastic event, fully organized by the students in at least the last 5 years. But without further ado, I want to give the word to great friends and colleagues. I visited them a month ago in Genoa. They held a fantastic conference in honor of Paolo Comanducci, a great Genovese professor. And I'm really glad that they're here with us today, even with some trouble. And this could be the first time that a flight from Ljubljana was late 2.5 hours ever. And I was looking at the history, and the history showed that it's always on time or early in 96% of the cases, which never happens, but from Ljubljana, obviously it does. So with us is Andrej Kristan, who is professor at the Giovanni Tarello Institute, University of Genoa, and Julieta Rabanos, who is also professor at the faculty of at the Giovanni Tarello Institute, University of Genoa, and we'll start our talks about language and law with them. So if they made a decision on who will start, Andrej, okay.
I've just arrived by taxi, like 15 minutes ago, no, half an hour ago. And this is my first jam session ever. So help me, please. What are the rules? How many people are jamming? I start, and then can I ask them to help me improvise? Yeah? Are you ready? Okay, let's see. No, but I have to take it. So, like this. Since we're coming from Genoa, you should know some things about legal philosophy in Genoa. One thing you should never forget is that we like to make distinctions, not just between law and language, right? Even inside of language or legal language. So let me ask you something. Do you think it's important to distinguish rules as textual formulations and rules as the meanings of the textual formulations? You all want to be lawyers, right? So when we speak of rules or norms, what are we referring to? Are we referring to some statutory provision, Article 215 of the whatever? Or are we referring to its meaning?
Its meaning.
And are you sure it makes sense to make this distinction? Why is it useful if you think it makes sense to make it?
Well, it makes sense to make a distinction because we have the norm, which is the same always, and we have the meaning, which we have to accommodate to the case we are looking at. So in that case, the norm, the essence of it is something that we have to derive from the norm, and the norm is something that is given to us again.
Okay, but I'd just like to understand better what you're saying, because I asked, what are you referring to when you say a norm, and he said a meaning. And then you said there's a norm, and then there's its meaning, so there's no meaning of meaning, probably.
No. There is the norm, and there is its formulation. Formulation is always given, but the norm is the essence, which we have to understand from formulation.
Just a technical requirement, use the mics, please, so that people online can hear you as well.
Is this okay? Yeah, better.
Yeah.
Okay. Yeah. So if you think of how lawyers speak, you will come to a conclusion that we usually use the term norm or rule or principle with different meanings. Sometimes we refer to the text of the norm, and sometimes we refer to the meaning of the norm or the essence, as you said. So the first thing, and this is what proves that distinctions are useful, is we should clarify if we want to be precise and don't enter into fallacies. We should clarify what are we referring to, what do we have in mind when we say, when we use an ambiguous term. Okay? So let's decide right away. If we say the norm here without any further specification, what will we be referring to? Let's just stipulate it so that we will understand each other.
Its meaning.
You prefer to call the meaning of the text of the statutory provision the norm. So whenever I will refer to the text, I'll say text or provision or textual formulation or normative formulation or something like that. Is that okay? And I ask you to do the same. Okay. Do you think it's useful to make the same distinction in the ordinary language as well, when we don't speak about law? Can you think of
Meanings of formulations and formulations. Between meanings and
between
formulations.
text and the meaning? Let's put it this way. Yeah.
Okay, yeah.
Yes, because it's still language, it still needs interpretation.
So what would be the reasons you would give if you'd have to explain to someone who says, "Oh, this is useless"? How would you explain it? It's important to make the distinction. And do you know the name, the technical terms used in the philosophy of language
For what? For meaning?
for this distinction? If I have a sentence written down on a piece of paper, how do you call its meaning?
I'm not certain about the technical term.
Anyone?
Again, you call it sense in the Freudian sense, the meaning of the words.
Yeah, the meaning of the words. Now I said the meaning of the sentence. Yeah, proposition might be one name for it, right? Fram, do you agree? Do you agree? I was asking whether you agree. About the meaning of the sentence is called a proposition.
If it's a propositional, yes, but it might not be.
Okay. See? See, so things get complicated later on. But let's say that we have a sentence, the snow is white. And then the meaning of this sentence would be proposition. Okay? Now, with this example, can you prove that it's important to make a distinction? You said that yes, it's important because even in ordinary language we make interpretations. So can you explain why is it important to make this distinction between the text and the meaning with this example?
The snow is white, right?
Yes, the snow is white. Because if the text, the snow is white, would only have one meaning, that the snow is white, and the proposition that the snow is white would only have one expression, the snow is white, then there would be no need to distinguish between the text and the proposition in this case, right? No. So you might have some cases in which it would be important to make a distinction, but not always. So I'm asking you, can you think of reasons to justify the distinction with this example?
I'm not sure about that, but is there a word for a drug called snow?
I'm not sure either, but I think
I'm not sure. You are not referring to that meaning. This snow is really white enough, like something of that sort. Huh? Would that then make sense? That it would be a completely different meaning within a different context?
So you would have one text that can be used to express two different prepositions. One that is referred to water being white in certain aggregate state, and the other that's referring to some cocaine, some drug being very white, right? So you'd have one sentence, one expression, and two different propositions. Yeah, that would be one reason. So if the relationship between text and meaning is not always one-to-one, then it's useful to make a distinction. So now we have one example. The snow is white, and you can mean water or cocaine.
Just for the record, I didn't mention cocaine. You did, and you were making like, oh, really? Yeah, there is a drug called snow.
It's streamed directly to the European Union. I have a true meaning of this. Actually, when somebody tells you something that's quite obvious, and you say the snow, yeah, and the snow is white, which is a metaphorical meaning. Basically, you told him that something that he said is completely obvious, so you can have third meaning also.
Like
metaphorical.
Self-evident.
When something is self-evident, you tend to say, yeah, and the snow is white.
Yeah, the water is wet. Something like that. Okay. So now we have one example where you have one expression, one textual formulation with at least two or three different meanings. Can you give me an opposite example? Can you think of a proposition that could be expressed with two different textual formulations? You don't need to raise the hand, it's jam session.
Andrej is taller than Miodrag.
How can you possibly express this proposition with a different textual formulation?
Miodrag is shorter than Andrej.
See? Or you could say the snow is white, la nieve es blanca, sneg je beel. Right? The same proposition expressed with a different textual expression. Okay, so now we have two reasons to make the distinction, right? Sometimes you have textual formulations that can be used or are in fact used with various different meanings, and even the same meaning, content, proposition can be expressed through various textual formulations. Now let's go back to law. Can you give me examples in law and say, even in law, we need to make this distinction that the Genoese are making all the time, from the times of Tarello on. I started with this because there's kind of a, yeah, Tarello Institute, it's named after Giovanni Tarello, who was the founder of what is now called the Genoese School of Analytical Legal Realism. He was not the only one making the distinction. It's not even his, but he was insisting on it a lot. given that we're trying to get to the foundations of law, I thought it would be good to start here. Can you just think of examples that you've learned in class or read somewhere of statutory provisions that are in fact or may be interpreted in two different ways? Or can you think of norms as meanings that are expressed with different textual formulations?
We did basically the entire last week, so yeah, their grades. No, their grades are going down as we speak. There's what did we? Okay, one that I was explaining. There's the ontic-modalities, and you have different ways of expressing the ontic-modalities. So, for example, could be a problem for them that's like. The government shall do this. The government is under the obligation to do this. The government must do this. So we were doing these ways of expressing the ontic modalities, which are usually in Serbian. You express it by either using the future tense or you express it by using the word must, which implies causality somehow. And then you express it. Most rarely you express it by using the word obligation, or it's obliged to, but it's actually an obligation. So we were doing this I think last week as one possibility, in the sense that you have different formulations by which you express the same deontic modality, an obligation, for example, or a permission, or that something is forbidden. But we were also doing these things because we were explaining in detail, like, we usually call it the logical structure of the norm and the formulation of the norm, because the norms are never formulated in the way their logical structure functions. And we split it into these four parts, like disposition, condition for disposition, condition for sanction. And now they did at least 100 examples of reformulating.
Oh, so you have examples in your head.
At least 100.
Give me an example. That's easier. Give me an example of one single legislative provision or regulatory provision that can be interpreted in two different ways, at least in two different ways.
That can be interpreted in different ways in terms of being restricted only to the criminal procedure or including also misdemeanor or some other kind of procedures.
Okay. More? Please.
For example, the norm that the judiciary branch of government shall be independent in relation to others. That was a relevant question in our country last year when we changed our constitution.
Only last year? Okay.
Yeah.
In my country, it's every day.
No, it's always relevant, but I mean, we were in the procedure of changing the norms of the constitution, and there was the question of how to make the judiciary truly independent. So the norm was there. It should be independent, but different people regarded the true meaning in different ways.
Oh, what's that?
Well, there was the question if the parliament should be in charge.
No. I'm wondering what's a true meaning. So there's a non-true meaning, and then there's a true meaning.
No. I mean, what they consider to be, in their perception, the true meaning. What they...
You understood, I'm just provoking you, right? Okay. And so what are the meanings, the possible meanings of this provision that you mentioned?
Well, some people said that the parliament should be in charge of deciding which people could be judges, because the parliament is the reflection of the will of the people, and the people are those who make the country through the social contract. And the others said that no, parliament should not be in charge of that, because that is a convergence between the legislatory and the judiciary branch. So one formulation was there and two opposite norms were derived from it.
Okay, can we get to a, thanks. Can we get to a simpler example? Something like the snow is white, is it water or is it cocaine? Yeah, sure.
The European Union.
Yes.
This is American constitutional law, but maybe one is so it's the cruel and prohibition on cruel and unusual. We set aside unusual, but cruel. One of the debates. I don't think it's the right way to frame the debate, but it's one way that it's generally taken to elicit possible ambiguity. Whether cruel refers to actual cruelty, like the
Physical.
property of cruelty, or whether it's popular morality, whatever it was in particular at the time, maybe at the current time, but more popularly contrasted with framers or society at the time considered cruel, which is not a particular way. It is a property, but it's not a moral property, it's a mental property. That's one case in which the same term might refer to that has practical and legal implications.
Bojan has tons of examples. He's the king of vagueness, so
Yeah,
that's a good thing, I think.
depending on the situation, really being the king of vagueness depends. Let me give you one.
But at least
Okay.
it sounds good.
It sounds
King
good.
of vagueness.
King of vagueness is fantastic. There's a provision of the Serbian constitution. The parliament convenes 2 times a year, or many constitutions. But I was wondering if they can figure out how is this, what are the possible meanings of the parliament convenes 2 times a year. That is, it can be, of course, it is ambiguous in the sense like, who is under the obligation to convene? So what happens if it doesn't convene? Who should convene the parliament in this sense? When the parliament should be convened? Is it a calendar year or is it the parliament year, the session year? So even these situations in which you have numerical basically values, you can have ambiguity and vagueness, or you can have multiple meanings of a single text.
Okay, you've already mentioned the technical terms I was aiming to. Vagueness and ambiguity, for example, are 2 groups of cases, right? I can give you another example from the Slovenian constitution that says, Article 103, about the mandate of the President of the Republic, says the President of the Republic is elected for a mandate of 5 years, at the most twice in a row. Now the question is whether someone can be a president for the 3rd time, non-consecutively. And some people say, well, of course, only the consecutive term is limited to the 2nd one, and then you have to make a pause, right? But non-consecutive mandates are not regulated by this provision, whereas others say, no, no, no. The provision says that the rule is that you're president once. There's one exception. If the 2nd mandate is directly consecutive to the 1st one, then you can be elected once more. So this would be a case of ambiguity of the provision, right? Okay. So, and then the other group of examples that show how the same text can express different meanings. Now there's a much bigger debate whether these are different meanings or meanings are indeterminate, but we won't go into this right now. You've already heard about the no vehicles in the park rule, right? So you all know that it's the textual formulation of this rule is ambiguous, right? Yeah, I thought it was vague. I was just trying you to see whether you're following. So is it clear why we need to make a distinction between the norm as the text and the norm as the meaning? Yes? No? Come on, help me. Yeah, okay,
Yes.
thanks. So let's go on. Some further bases, foundations. How are norms different from meanings of descriptive propositional sentences? Like before, we said that there's the text that the snow is white, and then there's the meaning, which is called a proposition that this text expresses or is used to express. Do you see any difference between this semantic entity, with semantic I mean the meaning content, and the meaning content of the rule, there should be no vehicles in the park?
A norm is normative. It tells us what to do, what ought to be. In a way, and the descriptive part is just saying what is.
So what's the difference between telling us what is and informing us about what is and informing us about what we ought to do?
Difference is the obligation. It's addressed towards someone who should act in a way, and when its description is just a statement, a fact, it doesn't address anyone.
Okay, can you see any further differences between these two meaning contents?
Well, I think the norm has a certain value because it tells us what should be the thing we are striving towards, whereas the descriptive sentence or provision is objective. Anyone could tell you that snow is white. It doesn't require any subjective elements, but in order to make a norm, you have to first define what is the ideal that we are supposed to try to achieve. So in that way, it has a value inside of it. A principle.
Okay. I was just thinking whether the word subjective is in place there, because I don't know people having problems with white, but some people don't see red as I do. Like, so there would be a subjective element even when we speak about colors, but still, yeah, you're right. Have you ever heard someone making the distinction in terms of truth conditions and truth values? Saying that you can evaluate a descriptive sentence as true or false. I mean, if I say the snow is green, someone would say, no, that's false. Right? Snow is white. That's true. Whereas if I say, leave the room, you couldn't evaluate the command, which expresses a norm, in the same terms of being true or being false, right? Why?
Because the second is the consequence of a will. It's a subjective personal formulation of something which one wills, which cannot be false. It's not a truth statement. It's not a fact statement.
So, can you make a parallel evaluation of a command, go out? How would you frame it? What could you say about it?
Go out.
Yeah,
The
if I
command.
first, yeah.
Well, yeah, it's the same. It's will formulation. It's you're asking someone to do something which is.
What? Yeah, sure. What I'm asking you is, when I said the snow is green, you said that's false.
Yeah.
Can you say something about my command? Can you evaluate my command in some way? You can't say it's true or false. Can you say something different about it?
We can say no to it. We can act differently than the command says, but we cannot evaluate it from a factual perspective.
But there are other values apart from true, untrue.
Yeah, of course, we can say it's
Unbased.
legitimate. It's
That was the
a value statement. Okay, of course.
Just, unjust.
Yeah.
No, of course, that's
You could, yeah, you could say it's valid and that I'm authorized to do it, that it's legitimate and so on. But there was something very interesting in what you said before. You said something about the factual situation, that you cannot evaluate it on the basis of the facts. Was that it? Yeah. Are you sure you cannot actually evaluate it on the basis of the facts? Go out. I order you, I command you to go out. Do you want to say something?
I mean, I feel like I'm cheating, but
No, that's the idea of the jam session, right?
yeah. So the idea with truth conditions is that there's something that makes the utterance, the descriptive utterance, so there's something that it achieves. It achieves truth, or it doesn't achieve truth, so it's false. And so with imperatives, I mean, you can formulate. There's a difference between saying you ought to fly, or you ought to go outside, or go outside. I think there's an important difference there, but if you focus just on go outside, one way to think about it is that the utterance achieves something if the world is a certain way, and it doesn't achieve something if the world isn't a certain way, and that might be determined by what? If I say Andrej, go outside, is my utterance successful when? Is the question that I throw at there.
So if I say the snow is green, my utterance is successful if the snow has the green color, right? If I say go out of the room, my utterance is successful if the world changes, in the fact changes, which means if the command gets satisfied, or yeah. Okay. So
I would think of far more simpler way. I mean, the utterance go out requires specific factual conditions for this utterance to be meaningful. If we are standing outside somewhere in the field and you tell me go out, it doesn't make sense. So you can say that in that particular sense, it's not even, you can even say it's not true, or it doesn't match some sort of true conditions for this utterance to happen. Or it would be like, if you have to formulate it more philosophically, it would basically boil down to Kantian "Ot implies can." So there has to be conditions of something to be possible at all for you to formulate it as an odd statement. So that might be one way to think of it.
again, there's a whole range of different conditions we won't go into, but one of them make it possible, others make it fallacious, right? And so on. So we won't go into that. I was just trying to open the perspective and see what the difference is, and now I would like to introduce a possible problem. So what we've come to is, we've said, first, it's useful to make a distinction between normative formulations, factual provisions, and their meanings. And we said lawyers and non-lawyers alike, they use the term norm or rule or principle ambiguously. Sometimes they refer to the text, sometimes they refer to their meaning. Here, in this audience, we've stipulated that when we say a norm, we're referring to the meaning, otherwise we will specify. And then we started thinking about what this kind of meaning, how is it like, and how is it different from other kinds of meaning, like of descriptive sentences. And we've seen that when we speak of descriptive sentences, the snow has a certain color, we can say that they are true or false. When we speak of norms, sometimes expressed as imperatives, just to make things easier, we wouldn't say, most people wouldn't say they have truth conditions and truth values. Okay, and then we have situations in which we reason with a mix of descriptive and normative sentences, right? You all know about judicial syllogism, I suppose. Have you ever heard the term judicial syllogism? Yeah? Or have you ever thought of how to simplify the structure of a judgment, the sentence of a court? How would you simplify it? Sometimes we say this as a form of an argument with normative premises and factual premises, and then there's a conclusion, right?
To simplify it even further, when judges are so those of you who are on their first year, they're going to do it in a couple of weeks. But when you reason, when you try to solve a case as a judge, we usually think of it as we are starting from a general legal norm or a legal text. We take some facts into account and we apply this norm to the facts of the case in order to reach the conclusion. And the conclusion usually is what we learned, I think, last week. It's a particular legal norm. You were talking about that with me, Andrej, on the lessons. So, and that's basically judicial syllogism. You start from a general norm, you take facts into consideration, and you arrive at a particular conclusion. That is the simplification of judicial reasoning that Andrej is mentioning.
Thanks. So, I said I will introduce some problems of the view that norms don't have truth values, with the example of how we use normative sentences together with descriptive sentences in reasoning. But let's first think of a descriptive syllogism. A syllogism is a valid form of argument. You've all heard about all men are mortal, Socrates is mortal, therefore, Socrates is a man, therefore Socrates is mortal. Right? You've heard this in gymnasia, in a philosophy course probably, right? So, this kind of argument is called modus ponens, but it doesn't really matter. And you all know that it's true, right? I mean, you know by the form of the argument that some arguments are always true. They are called deductive arguments. Why is this argument, this form of argument, always gives you a true conclusion? Or better, sorry, not true. A valid form of argument, I said. Why is it valid? What does it mean that it's valid?
It means that if we have true premises, they're proven as true, then the conclusion must be also.
Okay, can you give me a different example, different from the one about Socrates and his mortality? Preach.
All dolphins can swim. Socrates can swim. Socrates is a dolphin.
Is this a valid argument? What? Please speak.
Yeah, I think that that's a fallacy, because it's a fallacy called the affirmation of the consequent.
So can you repeat it so that we all understand why is it a fallacy?
So you have the argument, you have the syllogism or the proposed syllogism as all dolphins can swim, then Socrates can swim, then Socrates is a dolphin. But we can, so the thing here is that it would have been a valid argument if it were something on the likes of all dolphins can swim, Socrates is a dolphin,
Socrates can swim. But if you say something like Socrates can swim, therefore Socrates is a dolphin, you can think about things that are not a dolphin that can swim. But if you consider the first material conditionate, how do you say this in English?
Condition.
Yeah, thank you. If you take the first premise, the material conditional, as a true premise, then you're forced to say that if the antecedent obtains that it's true, then by also thinking that the first premise is true, you must conclude that the consequence is true. The consequent is true. But if you are trying to affirm the consequent, the conditional can still be true if the antecedent is not true. So it's
Can you prove it? Can you prove it?
Yes, but not in this moment. I would need to. I think I will need to.
We have a whole day dedicated to law and law.
Yeah, in fact, we are going
after
to have
tomorrow. So please come back. So this wasn't the right example, which was very, very useful to show that not every not every argument that looks like modus ponens is actually modus ponens. So can you give me another argument, another example of a valid argument? How is this an argument?
It's ergo sum. I think, therefore I exist.
Can we go to the form of modus
There are two
ponens, which means
different
let's
premises. It's one premise that makes my conclusion valid.
okay, what I'm looking for is our arguments. I'll go back to
Therefore I am.
Whatever thinks exists. So whatever thinks exists.
Therefore it
Bojan thinks, therefore Bojan exists. So
making this complicated for me.
yeah, but it's valid.
That's the beauty of jam sessions, right?
If you fall into water, you get wet. You fell into water, you are wet. That's valid syllogism.
That's a valid argument.
Yeah.
Now, how did you want to say something more? No. How would you explain in different terms when an argument is valid, deductively valid? Yeah, or just different words. Some people speak of the criterion of truth preservance, that it preserves the truth of the premises, which you explained in different terms, right?
Premises are true, the conclusion and the
If the
reasoning is valid.
Yeah, if the premises are true, the conclusion can't be false, right? So yeah, put differently. Which doesn't mean that if the conclusion is true, then that the premises are necessarily true. You could get a true conclusion from false premises. An invalid argument could give you something like this, right? Okay. All clear until here? More or less. Okay. So let's see mixed reasonings with premises that are normative and factual. Can you give me an example? So I'm sticking with the form of modus ponens, two premises, one conclusion, and I would like one normative premise, one factual premise, and a conclusion. I'm looking for this because, as you've learned last week, I think, most
Or not, or didn't. Yeah, they cared about.
If you receive a salary, you ought to pay tax. I receive a salary, I ought to pay tax.
So, can you identify the premises and the conclusion of what he just said? What would be the normative premise? If you receive a salary, you ought to pay taxes. What would be the, sorry?
Sorry. Or we did theft, which is very complicated to pronounce in Serbian and translate in English. But if you steal something, you go to jail or you get fined. I stole something, I go to jail or get fined. So those are the two premises and the conclusion. The first premise is the normative premise. I mean, I didn't formulate it very well normatively, but if I steal something, I ought to get fined, for example. Then it's clear that it's a normative premise. So we're doing this like. And the second premise, Bojan stole something, is obviously a factual premise. It states something about a state of the affairs situation in the world.
Okay, so if you have this kind of arguments, we all think they are valid, right? I mean, if you say, if you get a salary, you ought to pay taxes, the normative premise, and the factual premise. I got a salary, what's the conclusion? I ought to pay taxes, right? We would all say this is a valid argument. Same thing. If you steal something, you ought to go to prison, or you ought to be fined, or you ought to pay a fine. A normative premise, the factual premise. You stole something, what's the conclusion? You ought to pay the fine. And we would all say these are valid arguments, right? Now, if we understand validity of the argument as he explained very well before, and I put it in different terms as preservance of truth from the premises to the conclusion, how can you say that truth is preserved in this argument where I have a premise that is supposed not to have truth values? I mean, the normative one, right? I'll change the example now, just so that it's easier, and I'll go to an example with an imperative. If it rains, you ought to stay at home. Or I command you to, if it rains, I command you to stay at home. Yeah, not just ought. I ordered you to stay at home, okay? So this is a normative premise. The factual premise, it rains, it's raining. The conclusion would be, I command you to stay at home. If imperatives and norms don't have truth values, we should explain the validity of this argument in different terms, not as preservance of truth. What could it be? Now, before, when Ravan intervened, he said that there's some kind of achievement that we can speak about when we speak of norms, like a norm could be complied with, right? The command could be complied with. So one could say, okay, so in case of normative premises and arguments, we should define the validity not as the preservance of truth. As you also said before, we have other values we can attribute to norms. Let's speak of compliance. Would it work? Can we say that a valid legal argument is the one that preserves the compliance from the premises to the conclusion? Well, we can't do that because it's raining can't be evaluated in terms of compliance, right? So if compliance would work as for the normative premise, and it could be preserved in the conclusion, it doesn't work with the factual premise because the factual premise has a different value, that of truth. And so here's a little or a big problem. For the normal view, which says that norms and imperatives and so on don't have truth values, whereas descriptive sentences do. But here we have these arguments that we all consider valid. Now, obviously, there are various solutions to it, but I will show you one that goes against the majority view, which I claimed at the beginning, and we all accept, I think, that norms can't be considered as having truth values. So in the 70s, David Lewis already said that, talking about imperatives, he said that imperatives actually have truth values if we understand them correctly. And then in the 90s, Jackson and Pettit, these are all big names in analytic philosophy, claimed the same thing. They said that imperatives like go out of the room, or if it's raining, go out of the room, are basically elliptic expressions of performatives that can be used to the same effect. So if I say go out of the room, I can also say I command you to go out of the room, which means that I've used a performative to the same effect, telling you to go out of the room. But when you consider performatives like I command you to go out of the room, can you actually evaluate it in terms of truth or falsity? And Lewis said, well, of course you can. If the speaker actually commanded you to go out of the room, then the performative is true. Command is true. If it didn't, it's false. Now we can speak of various conditions that make it false. For example, if I say, I command you to go out of the room right away. Obviously, I'm doing it in a class. I don't intend to issue a command for you to leave the room because otherwise I'd stay without audience, right? So a command.
So the factual part actually encompasses intention or the subjective aspects of the command.
Yes, although you could frame it differently, but yeah, let's put it this way. This is one way of doing it. Yeah.
So for legal norms, we would actually have to evaluate whether it was actually given as a command, whether there was intention of commanding something.
Yeah. So basically, when the parliament says, if you steal, you ought to pay a fine, the parliament is saying, I'm commanding you to pay the fine if you steal. Something like that. Then you have further problems because there's a collective entity and so on. But still, please.
But it seems that every legal norm must encompass that sort of intention.
If you're a positivist. If you're not a positivist, not necessarily. You could think, I mean, I could think of some natural lawyer claiming that there's natural law, and that not all natural law depends on a commander. Yeah. Right?
Still.
Yeah. Why? Why do you need intention? I mean, I think you could do it without intention. That's not my point, but please.
No, but yeah, I understand. But as a counterexample, you couldn't really. Then you would still have to stipulate a kind of intention if you're stipulating at least like divine versions of natural law.
No, I'm saying non-divine versions. Non-divine versions.
But yeah.
If it's objectively existing, you don't need
an intention. Yeah.
It's the nature.
But you,
right? It's in human nature that we are this or that way, that we ought to do this or that. So I'm not saying that you should do it without intention. I'm definitely not telling you to be natural lawyers. But I think you could think of some versions of natural law that no one would support right now, perhaps, but that would work without intentions. So, this thing with imperatives and norms as ellipses of commands would work for positivists, or at least for the positive law, right? So, if I say, go out of the room if it's raining, or what did I say before? If it's raining, go to the cinema. We said you can't evaluate this in terms of truth or falsity unless you understand it as an ellipsis for the command. I command you to go to the cinema if it rains, right? And then in this case, it seems trivial, but still you could evaluate it in terms of truth or falsity. And you could say that the command is true or that the command is false. It is true if and only if I commanded that you go to the cinema if it's raining, and it's false if I didn't do it. Now, this is trivial for some purposes, but not for the purpose I'm introducing it here. I said if we consider imperatives, normative sentences, as ellipses of commands, then we lose the problem of mixed reasonings and the problem of defining validity of arguments we all consider valid, right? Because we could still speak of the preservance of truth that goes from the premises to the conclusion. Okay, now this is the solution proposed by Lewis and Jackson Pettit, but Bojan will object. No. Okay.
I don't really understand the solution. I think that you would need a second claim in order to claim that the command has truth value. A claim that you claimed that. So the factual thing that you're evaluating here is the fact that you claimed or you uttered the words "go out of the room," and we.
Or the Parliament did it. For example, if we stick to your.
But we are not truth evaluating the command. We're truth evaluating the claim about the command being uttered. Okay, so of course, like if I I'm going to stop soon because I'm going to overcomplicate things.
No, but basically you're saying that
yeah,
the Parliament commanded that you ought to pay the fine if
that's
you steal is ambiguous between a meaning that has truth values and the other one that is still only has compliance values.
I think
something like that.
Something like that. I don't know if you would need a different formulation, but something like that. In the sense that you're not claiming in this situation that the command has truth value, you're actually claiming that the statement about the command being issued has truth value, which kind of is a different.
You mean something like a Kelsenian legal rule, meaning the reconstruction of the meaning of a legal rule.
Yeah, so, but in this case,
something having truth conditions.
Yeah, but in this case, I don't have to be completely Kelsenian because we're talking about the Parliament uttering a sentence, and it's quite obvious that I can truth evaluate whether the Parliament uttered prohibited theft. If it did, it did. If it didn't, it didn't. It's just this factual matter. But like the very sentence, in the sense like theft is prohibited.
No, I'm just saying theft is prohibited is understood in this view as an ellipsis for the Parliament commanded you to pay the fine if you steal. Okay.
With the view, not with you claiming.
Yeah. Okay. So, but yeah, I'm fine. Sure. My question is, whether you think that this solves or doesn't solve the problem of the validity of mixed reasonings? Why not? Wouldn't it be enough that this kind of sentences are ambiguous so that you can actually show that the truth is preserved from the premises to the to the conclusion, because one version, one meaning of the premise, of the textual premise, the normative premise, still has truth values, and these can be preserved until the conclusion.
In the reformulated case, if it's an ellipsis, so under the condition, if this is the ellipsis. So
Yeah, sure. This is the theoretical trick, saying that always norms should be understood as ellipsis for commands.
Yeah, if there are ellipses for commands, if that starting point is true, it would quite obviously be true. But I'm not sure that there are ellipses. I'm not convinced that there are ellipses for commands, because you're actually basically turning something that is a command into something that is a description of a command, basically. That's why I have problems with this. So I could do this with.
But this is the case with performatives, right? I mean, I'm reporting on what I'm doing, and therefore I'm doing it. Something like that, right?
But is it?
But I think that there would be a difference between saying, for example, so saying that I'm doing this because of, and it's true that I'm doing this, and then saying that, for example, you ought to do that because I'm doing this.
I don't know, talk to Luis. Oh, I missed that.
No, we are trying to problematize the solution of this. Because if not, I think that it transforms the argument in a descriptive syllogism.
Well, that was the point of the whole theoretical endeavor. They did this just so that they could say.
But you are right to the conclusion, which is a descriptive, so a proposition in a wide sense. And then you have the problem about proposition direct behavior.
No, I think they would be a bit, I don't know how to say it. I don't think they would claim, and I didn't go back to the sources to check, so don't take my word on it, but I don't think they would claim that these sentences only have truth conditions and lost compliance conditions. I think they would say, apart from having compliance conditions and guiding behavior and so on, we can also consider them as having truth conditions, and this is enough to explain why we understand these kinds of arguments as valid.
Okay. So practical. No, okay. I think I understand you now. So
can you go check the sources until tomorrow after tomorrow?
You can Google it for an hour or two in order not to find it. Professor Hasanbegovic, I want to include, just if you don't mind, Professor Jasminka Hasanbegovic raised her hand, and she's been doing logic. I wouldn't be for like a very long time. So please, Professor.
I would like just to help a little bit concerning truthfulness of norms, rules, imperatives, etc. Only on a meta level we can speak about truth or false or of that is to say, exactly, some of you said, explaining only on the meta level we can speak about truthfulness or falseness of rules and norms and things like that. That is to say, we speak about true or false text of the norm, not about meaning. And on meta level, we can say, yes, the assembly or government or anybody, president, who whatever, said this and that, and it is true, or it is not true that this body had this said something or ordered or prohibited, but only concerning text, not the meaning. Meaning is something that has an additional value always, and that's why we cannot say about value that is in norm or rule or imperative that is true or false. We can say it is just, it is unjust, it is fair, it is not fair, it is elegantly formulated, or it's necessary complicated in formulation, but these are another values than truth as a value in legal reasoning.
Thank you, Professor. But now I think that I'm getting so just like to help you with the explanation. So basically, is this? It might be that when you reformulate it, it's not a command anymore, but since the command implies also this reformulation, this elliptical reformulation.
So you're saying it's not a command because it's a report on a command.
Yeah. But if every command implies this, basically what you're trying to do is explaining how truthfulness is transferred to the conclusion. And you can explain it only if the command has also this, as an ellipsis, has this.
Not only, but it's an easier way out. Otherwise, you should redefine validity for this kind of mixed reasonings. Okay. Now,
Andrej, can I ask one question? Why you started with the premise at all that we have to search for the truth conditions of the mixed propositions? Why is this the premise that we are working with? I know that it's important for lawyers because you want to transform it to what they will learn. Of course, you have a norm, then you have a factual condition, then you have a conclusion, and you want to say we come to a correct conclusion. But do we really, if we go back from kind of our standpoint and take one very common conclusion, take a judicial decision, do we ever speak about true judicial decisions? Do we ever speak about judicial decisions in terms of...
I hope we don't, because it's trivial, as we said earlier.
Yeah. But then, then why you start from the premise that mixed propositions should be inspected in truth condition in terms of truth condition?
Let's put it this way. The way we were taught later on, not as kids, to analyze the reasoning is at first they introduced us to deductive reasoning with descriptive sentences and premises, and then they defined validity on the basis of those as preservance of truth. That's why I mentioned you've heard about this in gymnasia. And then later on you started analyzing mixed reasonings with normative sentences, and in the literature, when you look at it, most analytic philosophers define validity as preservance of truth conditions, and then they say, oh, but then we have a problem with normative arguments that seem valid. So one way is to redefine validity and change terminology, not speak of truth, in order to explain validity. And some people do it with a lot of hustle, and it's too complicated to introduce it here. Some other great minds from last century, like David Lewis, Philip Pettit, Frank Jackson, Philip Pettit and Frank Jackson are still alive, said, oh, but we can do it differently. We can take the easy way and just say, no, look, all these norms, they're actually also ellipses of the command to the same effect. And if we take them as such, then we can explain why we take these kind of arguments as valid, because the truth is actually preserved from the premises to the conclusion if in the analysis of the argument you put the ellipsis, the command, in place of the norm or the imperative. Okay?
Definitely. I don't know about Mizrach, but I
So this is the explanation. Now it's more complicated because many people could object to the fact that we actually learn the descriptive parts of this to use the descriptive parts of discourse before we actually learn the imperative discourse, right? Because if you look at our kids, we first say, no, you can't do that. No, don't do this. No, do this. Before we say, oh, the snow is white. Look how beautiful is the sky. And even beautiful is not only descriptive. So anyhow, this is the explanation. But just before we go to have a pause, I would like to add one problem for this solution offered by Lewis and Jackson and Pettit. You know that when we analyze legal reasoning and norms and so on, we usually do it at the beginning, at least to identify contradictions, right? So if I say, if it's raining, go to the cinema. So this is one norm. And then the other norm says, if it's raining, don't go to the cinema. Obviously, we all feel that there's a contradiction to be identified, right? But if I now reformulate these two norms and put the ellipsis, the command, in their place, I get, if it's raining, someone commanded you to go to the cinema, and if it's raining, someone commanded you not to go to the cinema. There's no contradiction. Someone can actually command to do and not to do the same thing. Maybe someone who has a schizophrenia or something like that, but it doesn't really matter, right? So for the purposes of the analysis, this view that was supposed to bring us an easy solution to the question of how can we consider all these arguments as valid, turns out to be quite problematic. And there's another funny solution to this problem, very theoretical one, again, but very simple, and then we can go for a break. What's the solution? The solution was offered by Josh Parsons like 10 years ago. And he said, no, basically the ellipsis is a bit longer. When I say, if it's raining, go to the cinema, I'm not saying, if it's raining, I command you to go to the cinema. I'm saying, if it's raining, I command you to go to the cinema, and I don't command you not to go. And when you do this, and you add the contradictory, which was, don't go to the cinema if it's raining, and you transform it with the ellipsis, the long one, long version. If it's raining, I command you to go to the cinema, and I don't command you not to go. Anyhow, I'll have to put it down. But the fact is, if you write it down right now, I don't have a board here, right?
Okay, I will.
No.
Could be
Give me half a minute. But I think you've got the point, right? If I do the longer thing, the longer ellipsis, I command you to go to the cinema, and I don't command you not to go in the first place. And then in the second place, I say, I command you not to go to the cinema, and I don't command you to go to the cinema. There, the contradiction reappears again. With this simple view that helps us explain why we consider valid certain kinds of mixed reasonings that have normative and factual premises. I don't know how well I did on the jamming. I'm quite exhausted. I hope that
as in all jamming,
jamming, it's just like
you need something short.
Go to the cinema or not? I think that it will permanently remain an issue without no, it was I want to, because just a brief explanation, actually, at least for those students, because they are first year students here, and no,
I'm so
Especially,
sorry.
You guys stayed in the room, so that's good.
no, look, this is the thing. Actually,
Not all of them,
actually,
not
all
all
the
of them.
third part of the book is about going to the cinema and not going to the cinema.
But I lost the proof. There was no proof.
Yes, you'll be learning a lot about going to the cinema and not going to the cinema, but actually about legal syllogism, about legal interpretation, the possible meanings of words, the ambiguity, vagueness in the third part of the course in Introduction to Jurisprudence. So basically, the entirety of December, you'll be doing these things. So when you start doing it, mark my words, you'll remember what Andrej was explaining today in a very, very analytical way that you might not be used to, but that you should get used to, because it helps. Not only it's a more theoretically sound, precise, and overall it pinpoints the problems way better than other ways, but also because it is a tool that is often invaluable for lawyers in their work. So it might not seem so at first, but you'll see when we start doing this, when we start identifying ambiguities, when we start identifying contradictions, a lot of it hinges on having an analytical mind. So this was basically an introduction to it, and thank you, Andrej, for a wonderful introduction.
Thank you. Thanks.
Ah, 10 minutes pause. So yeah, you can all join us in the teachers club to make a pause, to make a short break. There's stuff to eat, stuff to drink.
Are you commanding them?
You can. So let us continue. Some of the students were mentioning that they had doubts about the possibility of interrupting professors. Go ahead. You're encouraged to interrupt, given the informal nature of or the jamming nature of the talks. So please raise your hand, interrupt, give us your arguments, questions. We will be thrilled. Andrej would have been thrilled, but his time is up. But Jules, Julieta, Rabanos will, I'm certain, also be thrilled if she gets your questions. Julieta is also from the University of Genoa. The topics were not settled in advance, so I don't have anything to say about your topic, but we'll hear about it
I
in a
don't
couple.
throw my topics.
Yeah, that's always good. That's
So
a
it would
good
be
start.
fantastic if you have questions, comments, something that you want to talk about. So first of all, thank you very much. Thank you for the patience of being here and then to hear all of this stuff like, oh, you can derive some validity from a normative premise or a factual premise. So I think that we can continue with the topics that we were discussing. Not exactly those topics, but some things that were being said when we were discussing these topics. For example, I remember that you talked about true meaning. So let's return for a moment to that idea of true meaning, for example, of a phrase or a text. Do you agree that there is a true meaning? Do you just think that people think that there is a true meaning? Can you elaborate?
Well, when I mentioned it first, I thought that people think there is a true meaning and everyone has their own true meaning, so to speak.
And for certain things, I believe there is an objective true meaning which we are supposed to figure out. But generally, I think it's all in the perception of an individual. So no, I don't think that in all cases we can say that there is one true meaning, which is just waiting for us to discover it.
In this sense, can you think about one of these things that would have some true meaning?
Well, to give a very, very simple example, but numbers have true meanings. I mean, if I say these are 3 fingers,
Yes,
1, 2, 3.
that is a really good sample, I think.
Can I just jump in?
No.
You said, okay.
Go.
If Raban is the king of vagueness, she's the king of authority, so I'm not continuing.
No, please jump.
You said some things have a true meaning. What I was asking myself.
Queen of authority.
Sorry?
The queen of authority.
You're right.
I have no issues.
Yeah. Well, it depends how you understand the king, but then still. You're right. You're right. You said a true meaning. Of course, but someone could say, yes, it has more than one. So what you're saying is true. It has a true meaning, an objective meaning, but it has more than one, various. Or when you say it has an objective meaning, you want to say it has one and only one correct meaning, and all the rest is just Humpty Dumpty. Which one?
Well, when I say objective, when I say objective meaning, I refer to certain cases where there is one and only true meaning. Numbers have only that one meaning. You can't say this is 3 and this is 3. Only one of them is true. But if we are talking about colors or something more complex, I wouldn't go into detail, there are more than one true meaning. So in that situation, there is a true meaning and another one and another one, and every person has their own true meaning of certain concepts. But I believe there are a select few concepts which have the true meaning, only one. If I don't know if I expressed myself correctly, but
yeah, no, I understood. Thanks.
So sorry. Whether we agree or not, I think that your explanation was really clear. In the sense of, for example, returning to something that Andrej was introducing, the idea of objective being different in this thing that we are trying to discuss, objective being something different from unique or to just one. Because there is a discussion when you talk about language and you talk about interpretation, about the possibility of having only one true meaning. Like there is one and only one true meaning, which is also an objective meaning, because if it were not objective, in which sense we can't say that it's only one in this sense. But then depending on the way in which you think, not you, but if you think about objectivity, you can arrive to the conclusion that there are different possible objective meanings of, for example, a phrase or a text, or not. Because you talked, I remember that you also talked about essential, for example, meaning or of something. And I understand now that you were thinking maybe about numbers when you talk about essential. But then, for example, how about thinking about objectivity in conventional, in a conventional way? So in the sense of an objective meaning being the meaning established by the uses of a community in one certain time. It's subjective. I introduce it. You can tell me if you find it useful. You can say that it's objective in the sense that it's not the meaning ascribed by anyone in particular, but it's the meaning that you can find in a community, in one time, and in one particular space.
Well, I don't really know the technical terms for describing what I have in mind, but I think there is a subjective meaning which one person has. There is the next level, which is what we're talking, the contextual meaning in one time era or one community or whatever. And there is, for me, the third level, which doesn't have anything to do with any one person or the community, but has its meaning on its own. I don't know if...
Can I jump in? I would say that the third level is impossible if we start from the premise that language is a construct and it comes from humans only, meaning objectivity can only be funded consensually. That's as far as we can go when language is concerned.
Well, yes, but I think that language is a construct which is used only to describe certain concepts which exist without our consensual making of those. So we can say that the word three may have different meanings in different languages or different whatever, but the idea of three, the concept which is just named by the word, I think it exists independently of people or communities or different time periods, and I think that meaning on the third level is something which has only one true meaning because it doesn't depend on anything else. It's there on its own.
Yeah. It really doesn't matter and shouldn't be one of your preoccupations that you don't know the technical terms to express yourself. You're doing it very well. But be careful when you say that a meaning has a true meaning and the only meaning is that, and see, a meaning is a meaning of something, right? So if three has a true meaning, this means that three that is not a meaning has a meaning that is three. You can't say that a meaning exists without an expression of the meaning. You can say that the concept of three exists. But if the concept is the meaning of something, it's the meaning of an expression. So when you make a connection with an expression, then how can it exist without people expressing, someone expressing it? That's a question.
Well, I think that, for example, democracy is a concept. You can call it democracy in English, democratia in Serbian, whatever. Those are the words. This is the language. But the concept of democracy is an idea that every person should have in their head when they use the dictionaries to transfer the barriers of different languages. However, that concept of democracy has a certain ingredient in its substance, which should be the third level, the meaning of the meaning, as you said. Because democracy as such, even if you move it from the language level to the level of an idea, is something that we can say, is this democracy or is this democracy? There is some space for interpretation. That's what I meant.
Although there is a
Really sure because we moved from
huge
numbers, which is good.
gap between number three and democracy.
The problem with numbers is that I'm trying to make sense out of this because, like, the meaning of the number three is three, and because it refers to an abstract object, because you can't really, like, there's nothing.
Maybe we moved too far from
Successor of two. Yeah. Okay.
in law. So what would be, can we say there is a true meaning of the provision which says speed limit on a highway shall not be higher than 130 kilometers per hour? Is there any other meaning apart from the true meaning of the number 130 in this respect? That's the question for lawyers. That's the question for lawyers. And that's the question for law and language that is kind of, that we can translate into like practical issues that are more interesting, I would say.
Nevertheless, I think that the discussion is relevant, but just in this sense. Depending on the conception of language that we have, we are being more inclined to accept, for example, there is a true meaning of the provisions, or to accept that maybe there is a true meaning, but depending on some things, for example, contextual things, there is a true meaning in this society in particular, in this moment in particular, and we can construct like, I don't remember this word in English, cornice? A frame.
Frame.
Oh, okay. A frame of objective true meanings, if we want to say that. Or we can say, no, we don't think about any objectivity in this sense. We think just it all depends on the interpreter, for example. Yes, exactly.
I know everything behind the story, but I'm just
No,
I'm just provoking whether there is
no, it's
sense to speak about true meaning of 130 in this respect.
okay. Oh, okay. You were talking about the numbers.
Yes. The number.
Okay, I'm so sorry. Yeah.
It's a good point. We do have a discussion. I mean, basically in our textbook, we kind of discussed among ourselves. Goran was here, but he has lectures with PhD students methodology, so he had to leave. But we had discussions about that, whether there is kind of a space of certain provisions that basically do not need ascription of meaning to the text, or they are kind of, if you say 130, then it's 130. So you are not really interpreting. You are really not interpreting. Okay, I know everything what Genoa school tells us. that's not the question. I'm just starting from the very basic things that they can also follow. You know, are we interpreting anything in the provision 130 is 130, or we are just measuring? Okay, we're just measuring that it was 131 or below that, and that's it.
So following up what Miodrag said, what do you think interpretation is? What do you think that we do or we don't do when we interpreted something? Because I think that this is one of the key things that you can think about when you think about language and law. There are no wrong answers to this question. So you're basically saying that there is interpretation in the sense of adscription of a meaning to a text. So if the meaning is clear, then there is no interpretation involved. Yeah, okay. Does anyone think differently about interpretation? Not you. Not you.
Well, I'd say we interpret every time we encounter a norm or anything spoken in a language, because language is just an array of symbols, words, or whatever. And we must first try to make the link between the language and the primary meanings of the words used. Then we must check if those primary meanings make sense. If not, go down to the secondary meanings, to the less used ones, more specific, however, to make the sense of the norm make sense. And then we must use that interpreted norm and apply it to the factual framework, and I got confused in this explanation, but yes. Yes, and then apply that norm which we interpreted to the factual framework we have and see what is the conclusion of that combination.
Okay, so I think. So sorry. I think that this is very interesting because I think that you started thinking and talking about interpretation of texts, and then you concluded with interpretation of facts. When you were saying we have the facts and then we have the norm and then we use the norm as a schema, for example, to interpret the facts.
Well, not only interpret the facts, but the norm. If the norm says if you steal, you will go to jail.
Yeah.
That's norm. If we interpret it, it doesn't mean anything if we don't have a situation to which we are applying it.
Oh.
Be it it may be the situation which really is happening, or it may be a hypothetical case which we are checking the norm upon. But the norm without a situation which might exist on any plane just doesn't make sense, because the norm is there to regulate the reality. I mean, I might be wrong, but that is kind of how I view things. Law doesn't exist on its own. Law is a system which exists in the context of other social factors.
I think that we have a legal positivist here. Yes, at least one. A true legal positivist. No, thank you. I think I quite agree with your vision, but I think that I can use what you said to introduce maybe a distinction, following the distinction thing, between what is called interpretation, abstract interpretation and concrete interpretation. Just think about these two things, but we are going to go back because we still don't really know what interpretation means.
Some of us think we do, but
stop spoiling the fun.
Could we simplify things by saying that on the textual level?
No, we cannot. That's first. It's forbidden to simplify anything.
Perhaps the answer could be that it is still interpretation when a text or the language is clear, because we have to establish whether or not it is clear, meaning that we're interpreting what is. What is the meaning?
Or can I follow on Sarah's comment? How would you react to this old saying from Roman law? And our kids, they love Roman law currently. They are just completely in huge love with the Roman law. In claris non fit interpretatio. That's something which lawyers use on everyday basis. That's basically something which is common for any legal tradition. So, in clarity, there is no need for interpretation. That's the saying. That's the Roman saying. So obviously, everything depends on clarity.
Yeah.
Which brings us back to the language, which brings us back to the nature of language and the meaning of words and all things. But why on earth there is such a thing so entrenched in all legal communities if interpretation is always ascription of meaning, as the Genoa school says?
There's a lot of stupid entrenched things.
Yeah,
but that was not my comment.
Yeah, that's one way to answer this.
No, but this is also, there is one rendition of this that I actually like, and it's the only rendition that I like. It's the rendition by Baltazar Bogišić, and it goes something like this. It's a part of the law that was valid at the end of the 18th century, and it says what is understood the same at 19th century, what is understood the same way by everyone. is not to be interpreted. So that is T's definition of clarity.
And by everyone, you only mean the parties involved in a case.
It's meant to blockade as a canon, basically. This in the sense,
or it can be hearty and reasonable, man.
No, it can't be a reasonable.
No, of course it can't.
It's obviously a real.
Definitely not.
It's obviously a real consensus about the meaning of something. So, and this makes sense. If we agree about the normative meaning of something, that there isn't any more quarrel about it.
So,
but
to say that
interpretation would be before this.
So, to say that the text is clear is to say that it's undisputed.
Yeah.
But still, someone, because you said it, the meaning was before, someone had to attribute the meaning and no one disputed it, and so we said the text is clear.
Or there was a congruence in the interpretation, complete congruence in the interpretation of text.
You can't say it that way. Because the guy said, in clarity non fit interpretatio, so they are claiming there is no interpretation.
What do we interpret? Do we interpret anything in the provision on 130 rule?
We do.
Yeah, I know what you have to say about
No. So we do interpret.
Okay. Can we adopt him in Genoa?
No, but the thing is that
take him.
It's not so now you're quarreling about the meaning of 130, of the number 130, but that's not actually what people do when they interpret.
Okay, but can I jump on this? 130. Is it actually 130?
Never.
Because we all know there are standards of tolerance. So if I go 134, so basically what the provision says, the speed limit is 130. This provision actually says the speed limit is 134. So the meaning of 130 is 134.
The normative meaning of but the normative meaning of the provision.
It's just a question whether you will apply the rule consistently or not. It's not a question of meaning of 130. You are basically that's the thing. You know, like there was a rule in the football game about the offside. Before we had VAR, there was kind of upon the interpretation of the judge whether somebody is the player is closest to the goalkeeper. Now when you have VAR and it shows you this ridiculous offside, you're suddenly you're pissed off because of this. How can this be an offside? But this is an offside. Actually, there's just a strict interpretation of the rule, which until this moment we did not have the possibility to follow. So in this case, it would be the same. Okay, he is driving now. It's 134, like 134. Leave me alone. It's just 4 kilometers over the speed limit.
So you're saying it's not that 130 means 134. You're saying
130 means 130.
Yeah, but they give you this tolerance to 134 because they know that perhaps you didn't know you were going 130. So there's only a question, an epistemic issue. That's what you're claiming. The same with VAR, right?
It's not a question of meaning. It's just a question of application.
So, but why would they?
And then you really ascribe different meaning to. But then you kind of you make the norm. You make the text to be somehow incomprehensible, and then you say, okay, 130 is actually not 130 for the purposes of this situation. We will say 134 is still 130.
To jump in.
Yeah, so we can remember the question like this: are you prohibited from going to 130, or are you prohibited from going to 134? How would you know that you're prohibited, that you're going 130 and not 134?
I don't know what you're asking. So, really, it's if you have a number 130 and this, I don't drive a car at all to start with.
Yeah, okay, that's a good exception.
So I cannot.
So maybe your example was just for the start, because
I like to make examples from things that I don't do.
After posing the question, I feel like this. Yeah, exactly. So, did you want to jump in?
Yes, I did. If I may add an idea, the norm is the speed limit is 130. Maybe the element which doesn't have the one true meaning is not the number 130, but the concept of a speed limit. Is the speed limit the border which we cannot cross, or is it the border which we may cross by 4 kilometers per hour? In which case 130 is 130, but the speed limit is not a rigid limit, but an orientation with the variation of 4.
Let's just for time constraints reason assume that Miodrag is wrong. So and we could
But just
for time constraint reasons, so we could go.
But you were actually asking what means interpretation.
Yeah, exactly.
Okay.
So, what is the meaning of interpretation?
Or to render it differently, when you say I have to interpret something, what do you mean by that?
Well, we mentioned the Latin saying in claris non interpretatio fit, I think there are 2 definitions of interpretation, the wider one and the narrower one. Yeah. The wider one would be any assigning of a meaning to a certain text or a sentence or whatever, and I think that wider interpretation is present always, because when we see a norm, we must try to see what the meaning of that norm is at the beginning. And if we, by that wider interpretation, decide that it is an undisputed meaning, we do not go further than that. We say this is clear and there is no reason for the narrower interpretation, which is the more problematic one, which concerns those cases in the gray area. Does this mean this or that? So, yeah.
So basically, thank you very much for your intervention. So basically, we can stipulate that interpretation is like an intellectual operation to go from a text to some meaning. And that's it. That is your wider concept of interpretation. And I think that that's, for example, the concept of interpretation that the Genoa school has, like an intellectual operation going from a text to a meaning.
I don't really think anything like a Genoa school exists, but that's another interpretive problem.
Yeah, exactly. But it's an interpretation of facts, not of texts. No, okay, so, but going from the idea that at least we can say that interpretation regarding texts is the intellectual passage from a text to some meaning. Okay, that's it. The problem that we are having here, we are having 2 problems, or we are contemporarily discussing 2 problems. One is the problem of the meaning of interpretation, and we are discovering that there are a lot of possibilities of using interpretation, and maybe interpretation is an ambiguous term, and what a clarification of that is needed. And then we are having problems about what the activity of interpretation is made of, in the sense of, for example, are we undertaking an interpretative activity when we are in front of a clear text or not, for example? So regarding the ambiguity of interpretation, we can have a first ambiguity, which is we talk about interpretation as an activity and as a product. We are thinking about interpretation as something that we are trying to do, an activity, and then something that we have already done, and that is the product of that interpretation. The second one is one that I mentioned, and it also appeared in this discussion about application, for example, which is abstract interpretation and concrete interpretation. Abstract interpretation can be seen as purely the passage from a text to a meaning, in abstract.
That's why it's also called text-oriented interpretation.
Yeah. And then we can have the concrete interpretation or the facts-orientated interpretation, which is when we are trying to decide if some facts are an instance of the norm or the antecedent of the norm, for example. If what happens in Genoa is a school, for example, if what happened between Andrej and Miodrag can be thought about as homicide, for example, or not. Okay, and we can go on. But the idea with this regards application. Concrete interpretation or facts-orientated interpretation regards application of a norm we already obtained. We don't know how. This is not important in this moment, but we are trying to apply it to a set of facts to see if it's, I'm so sorry for being redundant, but if it is applicable or not. Okay. Then we have a third ambiguity, which I think that it was also thought about or discussed about. We have the ambiguity between cognitive interpretation and decisionary interpretation. One, we can say that maybe when we are trying to see what meaning a word has, and we are trying to see just one meaning, for example, we are taking the word bank, and we can refer maybe to a financial institution, and then we can refer to one part of a river, like the sides of the river and stuff. Okay, we can, when we do cognitive interpretation, we are doing this activity. We are taking a text, for example, or a legal provision, and we are undertaking the activity of trying to get all the possible meanings a text or a legal provision has. And that's it. We just want to know if these are knowable. That is a discussion for another day, or maybe for the next 10 minutes. And then we have decisionary interpretation, which is the interpretation that fits within the interpretation that we were discussing, that it was being undertaken when the text is not clear. But in this distinction, decisionary interpretation is just the description of some meaning, of the meanings that we have already obtained by cognitive interpretation. So, for example, we have a legal provision that says that it is mandatory to go to the bank, for example, at 9 o'clock. Undertaking cognitive interpretation would mean saying that we think that this text, this legal provision, expresses maybe two norms. One that is, it is mandatory to go to the riverside at 9 o'clock, or it is mandatory to go to the financial entity at 9 o'clock. Okay. Then with the decisionary interpretation, we are choosing one of those meanings. We are saying these texts or this text means this. Or, for example, this is the norm that is expressed by this meaning. Then, for example, depending on the theory of interpretation that you have, you can further think about two types of decisions. Because I think that this Latin phrase, it's trying to say that interpretation has to be seen as a creative activity. In the sense of, if it is clear, it's not interpretation. If we discover the meaning, and all interpretation is creation of meaning. And this, for example, this Roman phrase, I think that is collapsing this idea of ascribing creatively a meaning to a text. So when you decide that the text means something, you can,
So-
for example, yeah,
Can I just ask, so there is non-creative ascription as well?
yeah, yeah, exactly. So, for example, yeah, exactly. So
normal, not there to be, non-creative ascription.
I now feel like Chris Pratt in Jurassic World. Yeah, so but that's a very good question. Can be some adscription which is creative? Yes. For example, if we take a theory of interpretation like the Genoese one, you can divide the decision between what is interpretation, decisionary interpretation in a strict sense, and creative interpretation. Creative interpretation is to choose a meaning that was not obtained by cognitive interpretation. Yeah, please. Thank you. Okay, thank you.
So I have an example of that creative interpretation.
Oh, please.
Okay. So once I mentioned this in Mr. Jovanovic class, and it's about Roman emperors. Two emperors made a deal, let's say, in that context, that they will not attack each other's fields in 40 days. And one of the emperors actually attacked the fields at night time because he interpreted these 40 days as 40 days when the sun is when it's sunny, or when it's daylight, when it's not dark outside. And there is something, and there is Latin, to be more exact, summum ius summa iuria, for that interpretation. And I think there is one more illustrative example nowadays. For example, when we were talking about this number 130 on the highway, it's only written 130. There is not kilometers per hour, and American can interpret that as miles per hour. And then that automatically means higher speed, because 130 miles per.
So basically double.
Double, yes, because 80 miles per hour is equally to 130 kilometers per hour.
Yeah.
Yes.
Well, I
There is
really
also saying ignorantia legis nort.
yes. So my master in Argentina used to say that lawyers are obsessed with two things. Water metaphors, like for example in Spanish, source would be fountain. And gaps would be lagunas, which is lakes or something like that. And then the other one is that we are obsessed with Latin things. And I think that he was really right. He was really right about a bunch of things, but this is a funny thing. Thank you very much for the examples. I didn't know the Roman one. I think that I will use it because I think that it's really funny. And the other one, I think, well, this is a very interesting thing because, for example, yeah, it's true that, for example, a person from the United States that comes here and sees 130 kilometers per hour can think that for some reason in Serbia you use miles per hour. I think that that's a thing that the people from the United States can think about. Like, for example, that all the world uses Fahrenheit, for example, degrees.
Also, people from Serbia think that it's in miles, given the way they drive. So it's not just...
Well, but that's a rationalization. But yeah, so I would say that the same in Argentina. But yeah, but coming to the 130 kilometers, and I think that you can say that, for example, that interpretation in Serbia, like a person from the United States interpreting this 130 sign in one of your highways is a creative interpretation. Why? Because using the interpretative methods in force that you have in Serbia, there is no possibility of interpreting this as miles per hour. So, with this frame constituted by all these interpretative methods in force now in Serbia, you can separate between a decision which is within the frame, which can be thought about decisionary interpretation stricto sensu, to continue with the Latin things, and then creative interpretation if you ascribe a meaning which is outside this frame. For example, the miles per hour thing. So your example, I think that was top notch. No, thank you very much. Okay, so this was a third ambiguity of the word interpretation. We have one more, which is the ambiguity between what can be called interpretation stricto sensu, but not decisionary interpretation stricto sensu. Interpretation as such, stricto sensu, and then legal construction. Do you want to jump in?
I think, yeah, I'm tired. So the first ambiguity, interpretation as activity or process, and interpretation as product or result of this process.
Yes.
The second ambiguity, text-oriented and fact-oriented interpretation, or interpretation abstracto and interpretation concreto.
Yep.
The third ambiguity, cognitive and decisionary interpretation, and then stricto sensu and whatever you just said, and I forgot.
Creative.
Creative. Okay, thanks.
Yeah. Thank you for the
recap.
Yeah, thank you very much. I'm also tired, so the English is like going away. And then we have a possible fourth ambiguity, which is between interpretation stricto sensu and legal construction, which is the difference, the basic difference between something that you can say that it was obtained from texts, for example, obtained from legal provisions. You can really say that this is the meaning of some legal provisions using some types of arguments. We don't think about that in this moment. And then you have legal construction, which is, for example, obtaining norms or meanings that are not possible to be ascribed or related directly with some legal provision. For example, when there is a gap in the sense of there is a case that is not regulated by any norm, and then you use some kind of argument, bless you, some kind of argument like, oh, this case seems similar than the other one which is regulated, so it should have the same solution, right? And then you arrive to the conclusion that, for example, if something happens, then this is the solution. And the solution is the same as the other case which is regulated. This is legal construction. Obtaining this norm, which is, for example, called inexpressive norm, like a norm that was not expressed by some legal provision, this is an activity of legal construction, for example. But these activities can be thought about interpretation if you have some theory of interpretation. For example, the activities or what interpretation means in the phrase, the Latin phrase, that if it's clear, you don't interpret. In that case, interpretation means creation. You don't really know if creation in the sense of ascribing a meaning that is outside the frame in this sense, or if you are saying we are coming with a norm directly, like this, and that's it. Okay, this is all the things, for example, that we can, or we are discussing in a wide sense when we started talking about language and we started talking about true meaning or the possibility of true meaning. And then when we stopped discussing about numbers. But one thing that was...
Can you just stop for a while and...
Stop? Yes. Please.
Find examples for each and every one of these things that you've just mentioned.
Yeah. Do you
so let's start with interpretation as a process and interpretation as a result or a product of this process. Can you give us an example? Just to show whether you've understood the distinction or not.
We can help all with an example, Jules, and also. So
just give them a half example and then
it would seem obvious that interpretation is like an activity in which your brain, metaphorically speaking, is engaged. So you have to figure something out. Yeah. And the process of interpretation would be this process of figuring out the meaning of something. That would be the process, like all your cognitive activities included in the establishing of a meaning of something. What would then be the result?
Can I stop you? Just for let's suppose that we have a constitution of whatever country in the world that says men have the right to vote. And now we have a female colleague who wants to vote. Now the question is whether she has the right to vote and or doesn't have the right to vote. Interpretation as a process could go this way. Men have the right to vote. Men means mankind. Women are part of mankind, therefore women have the right to vote. Or it could go the other way. Men have the right to vote. Women are not men. A contrario, therefore, women don't have the right to vote. Or it could go differently again. Men have the right to vote. Men have the right to vote because they are part of the mankind. Women are likely, just as men, part of the mankind. So even though there's a gap, women have the right to vote by analogous reasoning. All these discourses that took me a couple of seconds to develop are an example of interpretation as a process. Okay, parting from a legal provision, adding some interpretative arguments like analogical or a contrario, and then coming to a conclusion. So this is interpretation as a process. What is interpretation as a product or result of this process? What would it be?
What do you think?
Well, the conclusion, the meaning which we got from the process.
The meaning or understanding.
Yes,
yes. The result of interpretation. And interpretation as a process is means for the result. The result is meaning or understanding of the text.
Yeah. So this was one ambiguity. Then let's go to the other one. Text-oriented and fact-oriented interpretation. Now, you can ask, men have the right to vote. When you ask yourself whether you should understand or interpret men as members of mankind or just men that are not female, women, this is text-oriented interpretation. You can do it in abstract, right? Just combining meanings, comparing the meanings of words, okay? And then what would it be a text-oriented interpretation? Fact-oriented interpretation. You can only do it in relation to some factual circumstances. Perhaps you have, how's it called? You know, man-wolf or something like that, or an alien. What?
Werewolf? A man-wolf?
Oh, good luck. Не знаю, как это скажет. Werewolf, right? And you ask yourself, okay, so is this a man or isn't a man? Like this would be fact-oriented interpretation.
Like to go back to the, there is the prohibition of the vehicles in the park. What happens with a tricycle, for example? It's a vehicle?
Okay, so
yes.
Yeah.
Yes.
This is
Okay, so let's go to the third ambiguity between cognitive and decisionary interpretation.
I gave some.
So we can skip this one. Or not?
If I may just add text-oriented interpretation is interpretation, let's say, stricto sensu. Text-oriented interpretation is not interpretation, it is qualification, legal qualification of the facts. And facts are always something contingent and something real that happen in reality, and we interpret the reality in terms we qualified what happens in a legal sense. We qualify facts and we interpret text.
Yeah, you could basically say that some people call it qualification of facts, other people call it interpretation, fact-oriented interpretation, other people call it application of the law. Okay, so these are different names. Perhaps there are some differences in details, but
yeah, I think if you, and this is the last thing, I think that if you think about it in the sense of trying to do with something with meanings, you are trying to define, for example, the reference of some term. For example, this is an instance, so this is referenced by the text that we already established the sense of, like the definition of in the abstract interpretation, question mark.
I will just do the moderating bit because in this hall at 6 o'clock starts the faculty's council, and we have to finish by 5:15. So,
what does it mean?
That we have to finish, but
I could render it in a couple of ways. I just chose this one.
It means that we have to empty the room.
What? Empty the room? What do you mean? Do we have to take the tables with us? Okay. Yeah, so I'll do some final comments, but I want to give the word for comments to Julieta and to...
No, so all the things that we discussed about interpretation are part of the things that you, when you analyze the relation between language and law, you can find. Especially we didn't have the opportunity to talk about theories of interpretation, at least in a very analytical and explicit way. We have been talking about theories of interpretation in the sense of what we think the activity of interpretation means, or what we think that activity of interpretation entails, when we were discussing about, okay, interpretation is just the ascription of some meaning if the text is unclear, for example, and if the text is clear, is no interpretation, it's just, for example, discovery of some meaning, which is there. This can be thought as an eclectic theory of interpretation. Interpretation is an activity of discovery if the text is clear, if it's an activity of ascription if the text is not clear. Then we talked about the skeptical theory of interpretation in a very wide sense when we talked about these differences between, for example, interpretation, cognitive interpretation and decisionary interpretation, because for example, the skeptical theory of interpretation, they think that everything is ascribing of meaning. The thing that you can say if it is correct in the sense of if it is interpretation, if it is within the frame or not, if it is creation of law. And this the moderate version of the skeptical theory. If you are a radical skepticist, you are saying, yep, you're saying there is no meaning before interpretation. So there is no meaning before the interpreter, and yeah, everything goes. And then we have like the cognitivist approach or the cognitivist theory of interpretation. They think that there is a true meaning for every term and every legal provision. No. And they think, for example, that every legal provision has one and only one meaning that has to be discovered, and then you can say that every ascription of meaning that does not coincide with that true meaning is incorrect. Why does it have to do with anything in law faculty or in a practical sense? Because this can allow you to criticize the decisions of, for example, judicial authorities or other lawyers or the administration. You can say this is the incorrect way to interpret this legal provision, for example. Or you can say, well, in this case, you don't have to interpret. It's clear. So we don't have to have this discussion. It's clear. Is this? And then you can say, well, there is nothing before your decision, so please just be persuaded of my arguments and just choose this interpretation for this legal provision. But all of these are, in some sense, tools to try to analyze this. In fact, for example, the things that we were discussing in the first part of the jam session about if we could say that, in some sense, all the discussion about can you derive or can you preserve the truth from a normative premise to the conclusion using traditional logic analysis, like deductive analysis, they are all tools to analyze, for example, if some decision is justified or not.
Just 2 sentences. The funny thing is not to say, to figure out which theory is correct or incorrect. The funny thing is to see how you can explain the same phenomena with different theories. Because most of the phenomena you can actually explain with various theories, and then you get to some marginal problems that some theory can actually explain and others can't, or that some explain it better or easier. Okay, so the fun is to see how to do it with different theories and then to compare it, not to say Miodrag is right.
You could think of it also this way, like there is this like we usually think of law as something closing things or deciding things or giving final answers to quarrels, giving final answers to things, and that is true. But in order to arrive at those final answers, you have to be able to notice possibilities. So when you discuss interpretation in this way, you're actually learning to see possibilities where at first there are none. And lawyers do that all the time. We call it in various ways, like we say colloquially, he found a gap in the law, or those are not gaps. You find a way, and lawyers do this for a living, find a way to interpret law in order to make their case. Prosecutors find a way to interpret law to make their case. So usually in legal texts, especially when you start the faculty of law, you see definite answers to questions, but in fact what lawyers see, seasoned lawyers, are usually possibilities that favor certain outcomes of cases, because lawyers are in it to win. Judges, on the other hand, have the final say in this, so the meaning ascribed by the judges or by the highest court authorities will be the meaning that is part of the law of the land usually. By doing these things, by thinking about interpretation even on the abstract level and on a less abstract level, you actually start to notice that what appears to be a definite statement is actually one of the possible interpretations of legal text. And I think that Andrej and Julieta did a wonderful job presenting that today.
I have only one conclusion.
Yeah. One does not simply ascribe a meaning to a text or walk into Mordor.
I think that this is the conclusion.
Yeah. Yeah. Thank you all.
Thank you. Thank you, Bojan. Thank you, Julieta.
Switching from the language to practical rationality, Hraf Nasgevson was today with us. He was participating, and tomorrow he is going to jam tomorrow, along with others from Surrey. So see you tomorrow, guys. Thank you.